Hi, good morning. I'm Judson Thomasis. It is 10:02 a.m., January 23. This is the case styled as Preston and Hales, cases 38-2023 DR416. We're here on several motions from both sides. Status conference last week. Court was notified that the limited notice of appearance filed on behalf of the petitioner was to address matters related to changing the date currently scheduled for January 26 to reconvene and resolve this matter. And respondent, or on respondent's behalf, counsel advised, in part, I believe, that they were seeking a continuance or potentially for different reasons, wholly different reasons, and other matters related to that. And the court directed that the parties by 5 p.m. on Friday, January 19th, file their respective motions. This matter is noticed for hearing January 18. 1 hour is set aside. I've got some preliminary comments. It'll eat into the time. I'm still going to allow and provide both counsel for each party 30 minutes apiece to present their arguments, but I want to comment on a few matters. The petitioner's motion to continue evidentiary hearing, which is scheduled to be resolved and adjudicated today, was filed January 19th at 8:12 p.m. The respondent filed on 1/19 at 5:22 p.m. what's styled as motion for sanctions, including voluntary dismissal, attorney's fees and costs, and related relief. The matters filed subsequent to that filed in effect today, really yesterday specifically, filed on January 22, Monday at 6:59 p.m., which is effectively today. The cover communication to my judicial assistant states, attached is the case law portion to go with the motion for sanctions filed on Friday. The fact is, what's attached to it does not contain even one case, one copy of a case at all, so it's not a case law portion. It's styled as a memorandum of law with no cases attached to it, but certainly some cited within it, but it is primarily an argument, and it's considered as such. And so we've got, and it'll come up later, we'll certainly address non-compliance with the directive regarding timing of filing documents, late filing, effectively this morning or 7 o'clock last night, filing additional argument. Counsel's got 30 minutes to present their case on both sides. The matter is this: January 26th scheduled. Counsel for the petitioner filed what's styled as a notice of limited appearance on January 17 for the purpose of addressing a motion to continue the January 26th hearing. And it's clear to the court, and it should be clear to the petitioner, that if the court doesn't grant that relief, she may be without this counsel to represent her. And so prospective counsel, in a way, but who files a limited notice of appearance to address this issue, we're going to address here today. That has been characterized in part, or part of the characterization in this argument, which in one part was called case law and really is not case law, and is styled as a memorandum but really is wholly including extreme argument, quite frankly, that describes in part the filing of the limited notice of appearance and the late appearance of an attorney potentially on behalf of the petitioner, but accurately today here on her behalf to argue a motion to continue. The length of continuance will be addressed if it's to be continued. But we've got language in this, quote, memorandum of law, unquote, which is not really a memorandum of law, that states in relevant part as to this issue, calling counsel for the petitioner, who's really just trying to address the issue of calendaring, that it's a ridiculous excuse for an attorney who's coming into a case that's already scheduled for trial. Attorney Silverman is no exception to the principle that an attorney takes the case as he finds it. He should have declined representation if he couldn't fulfill his responsibility of being here on January 26. He has no good cause. He's acting with contumacious disregard of the court authority, bad faith, willful disregard, gross indifference to an order of the court, conduct that evinces deliberate callousness, intentional abject interference with the orderly progression of the case, and going further and further. And I point that out because I want it to be addressed by both counsel that the record actually shows that on November 29, when the respondent was represented by counsel Mark Feather, when offered an opportunity to reconvene the following morning at 9 a.m., and I'll get into that, his misrepresentations to the court, which gained his client the first of many continuances, misrepresented why the continuance is necessary. The court relied on the misrepresentation, granted the continuance, and then when the court scheduled it for the following week, and Mr. Feather represented no objection to that date, and the court said, this will be a priority, it's going next week. There was no pushback, there was no judge, but I might have something. And then he files, again, another filing after hours, basically the Monday before the Wednesday hearing, a motion to continue that does nothing to point out that something came up between agreeing to the court date and the actual court date, but instead, in relevant part as it relates to today, Mr. Shockett, who is co-counsel to Mr. Feather, files a notice of appearance 24 hours and 20 minutes prior to the commencement of the hearing that was scheduled to conclude these proceedings on December 6th. And so for counsel, and this is concerning to the court, for counsel to describe the actions of an attorney who steps in with a limited notice trying to address the limited issue of the calendaring of the event that's now scheduled for 26, which he's already told the court, I can't be here, but can you allow me to be heard as to that matter? We have an attorney calling that bad faith, willful disregard, indifference, unprofessional, intentional, abject interference. And nonetheless, we're dealing with current co-counsel of the respondent, who 24 hours and 20 minutes took on a case that he knew he could not be prepared for, and he filed another motion to continue, which would have been about the third motion to continue, if not the second, depending on how you look at it, on behalf of the respondent. And so I would just suggest you all evaluate the context in which we are brought here today and keep the extraneous, unnecessary name-calling and characterization when the record evidence establishes that the court accommodated current respondent's counsel when he needed a continuance because he said he couldn't be prepared, because he got into the case knowing the case was scheduled, and he came in as co-counsel to a lawyer that told this court on November 29, somewhere between 4:50 p.m. and 5 p.m., Judge, I only need about 15 more minutes to conclude the entirety of my case. I found that to be incredulous understatement of the morning. I don't know of a lawyer who could have, because he said he needed to present 2 additional witnesses. He needed to cross-examine a petitioner who at that time took about 2 hours to not even get through with her direct testimony. And He didn't even address whether he was going to call his client and or maybe forgot whether he was going to make legal argument to the court. There was no way anyone, after this judge has spent 40 years almost on a daily basis in a courtroom, could have done that in 15 minutes. But in that context, current counsel, co-counsel of Mr. Feather, Mr. Shockett, took the case and said he couldn't be ready because he only had 24 hours and 20 minutes. And this court again accommodated the respondent. I want you to keep that context in mind. The court's taken 12 minutes of your time. Mr. Silverman, it's your motion that's first up on the docket.
Yes, Your Honor. Well, firstly, that's what I want to address. The first thing I want to note is I saw Mr. Shockett reference in his email to the court on Friday, and the court just referenced it, a 5 p.m. deadline on Friday. I'll be candid, I don't recall from I remember the court saying we had to file by Friday. I don't recall 5 p.m. If the court said it, I do apologize. I don't fault Mr. Shockett for filing after 5 p.m. The initial motion he filed. Obviously, I filed mine 7-something p.m., but both were filed on Friday. What I do object to is Mr. Shockett's motion being heard today. The reason I object to that is when Mr. Shockett filed that motion, forwarded it to the court on Friday, he indicated there was additional authority, additional information he wanted to include. As the court noted, that was not filed with the court, styled as a memorandum of law until, I believe, 7 p.m., 6:55 p.m. Yesterday evening. So it was filed almost 2 hours after the close of business, the evening before a 10 a.m. hearing the following day. I don't engage in trial or hearing by ambush. I respectfully ask the court to decline to allow Mr. Hales and his counsel the opportunity to do the same. Candidly, I had a rather full calendar with my family last night. I did not have, well, I've read what was filed last night. I've not had the opportunity to go through it in full and to pull all the cases and read everything. I therefore object to it being heard today. We can reserve for another day the arguments I have on the fact that the motion or whatever it is completely unfounded, fails to cite relevant law, and the law that I have been able to review thus far seems to indicate it doesn't support what they're asking for. But I am before the court on a limited basis, pursuant to the rules of family law procedure, asking the court to continue this Friday's hearing. Contrary to the, as the court noted, rather bombastic assertions in the pleading filed yesterday evening, I have done what I think is the appropriate and ethical thing to do here, because when Ms. Preston contacted me, I knew I would not be available this Friday. I will not make a full plenary notice of appearance in the case if I know I'm unavailable for a trial or hearing date that's already set. That is why, pursuant to the family law rules of procedure, I have filed a limited notice of appearance, asking this court to consider continuation of Friday's hearing. As the court correctly noted, if the court denies the continuance, I will not be able to represent my client on Friday, and Ms. Preston is fully aware of that. If the court denies the continuance today, I imagine the court will be getting from me a motion to withdraw, a stipulated motion to withdraw before the end of the day. With that being said, the court has laid quite a bit of the record already. This case has been previously continued, I believe multiple times at the request of the respondent and or his counsel. I have not yet obtained the videos of the court proceedings, although I've had, I was about to say the pleasure, but I would say more displeasure of having reviewed at least some of what Mr. Hales has posted online. And there are excerpts of that court proceeding online, which I understand is the subject of another proceeding in this case next Monday. I think that on an equitable basis, Your Honor, as I point out in the motion, both parties are entitled to representation by counsel. This court has previously continued this case at the request of Mr. Hales so that his counsel could be accommodated. I'm asking the court to do the same in this case so that my client's counsel, potential counsel, can be accommodated. This is obviously a complex case. There are issues related to the Fifth Amendment. I think those are, I point that out in my motion to continue. Mr. Shockett raised it in an entirely different manner in the document he filed last night. Regardless, I am aware from the State Attorney's Office that there are criminal allegations against both of these parties. And so the stakes are somewhat higher than they might be in another civil case of a similar character. And so for the reasons I cited in the motion, Your Honor, it is very important that my client be represented by counsel. The case law that I do cite in my motion clearly stands for the proposition that continuances should be granted when reasonable and when not overly prejudicial to accommodate a litigant's request to obtain counsel in the context of injunction proceedings and that is precisely what we are asking the court to do this morning. It is not, although this is a somewhat complex case, this request is not really complex, and so I'm otherwise going to stand by what's in the motion, and I think it clearly sets forth a reasonable and quite frankly compelling case for a reasonable continuance of Friday's hearing.
Thank you, counsel. Let me just ask you before I turn to respondents' counsel, with regards to the length of continuance, obviously the court has to weigh any potential prejudice to the respondent who has currently a temporary injunction in place that has been modified effectively on 2 occasions by this court in conformity with the Second District Court of Appeals opinion. That's the most recent modification, issued 12/29. This court, in conformity with that, modified it to his benefit to some extent. But obviously the court needs to weigh the length of the continuance in light of the totality of the circumstances, which I'll discuss at a relevant point here this morning. And so give me a sense, for instance, the case can be continued to the following week. It could be 2 weeks. Give me a sense of what you think you need to be ready and prepared. What really becomes, and just in short, day one was continued, and despite offering to reconvene the following morning, November 29 to November 30th, and the respondent, as I mentioned before, asked for longer time. When we reconvened early January, there was a bomb threat in the middle of the hearing, and thus we did not complete that day's events, and so we're scheduled for the 26th. So in effect, it's the third day of the continuation. And I understand that you want to obtain copies of the court proceedings, so just give me a sense what you think the time frame reasonably would be for you to be prepared.
Obtaining copies of the court proceedings is not, Mr. Lanier, my paralegal, is already sort of working on that. I don't anticipate I'll have any difficulty with that. I don't think any of the other business directed to Mr. Feather applies to me or my office, so we shouldn't have any. I should have those in the next couple of days. I do intend to depose Mr. Hales, and I believe that can be accomplished in short order, probably within the next 10 days. When we get to the appropriate part about any motions they're bringing with respect to discovery, which again, respectfully, I don't believe are properly before the court today, I believe that Mr. Hales, through counsel, if he can properly serve Mr. Cook with a subpoena, has the right to depose Mr. Cook, so I know he intends to take that deposition. As to a further deposition of my client, again, when we get to the appropriate date and time to hear that motion and the memorandum or whatever it is that Mr. Shockett filed last night, we could have a long discussion about the fact that it has improperly included communications between his office and mine in violation of the Florida Bar Rules of Professional Conduct. We can talk about the fact that he left out the fact that I have made a motion for 12.310D to terminate or limit my client's deposition. We can talk about the fact that it was improperly noticed. It was taken as a video deposition when not properly noticed as such, and then Mr. Hales pasted the video of the deposition all over YouTube. We'll get to all that. I don't expect that he's going to be permitted to depose my client any further, but he does have an opportunity, if he can serve Mr. Cook properly, to take Mr. Cook's deposition. So I figure we
Judge, none of this is relevant to the motion to continue. But
well, and so
because I'm asking him what needs to be accomplished.
What he's saying, what's not going to be accomplished.
Right, so we have 2 depositions that need to be taken. I believe we can get that accomplished in the better part of a day, if not an afternoon or a morning. So I would think at this point a 2 to 3 week continuance would be appropriate.
Okay.
So that's where
I just want to get a sense. We'll narrow down that request. Mr. Shockett, let's first address the issue of why or why not should we address what was characterized late last night after hours as case law, which was not case law. It was titled Memorandum of Law, but really is an argument, which certainly you could make argument. We're here for argument on issues. But with regards to the laundry list of sanctions that you're seeking, there's an objection to hearing that today.
Sure. Thanks, Your Honor. Good morning. I'm going to answer the continuance issue by giving a little history first. Obviously, let's start from the beginning. They already have effectively gotten a continuance. Your Honor recalls, she didn't appear for her, we were supposed to finish on January 4th. She was supposed to appear for her deposition December 21st, so was Mr. Cook. They didn't show up. They filed motions, she filed a motion to reschedule her deposition. She also filed a motion to not take Mr. Cook's deposition. The day of the bomb scare, Your Honor ruled that both of those depositions need to go forward. And we scheduled them here in open court on the 16th and the 17th. On the 16th, this is what's shown here, we can, we'll address the issue whether this is ready for today, but you know what happened, Judge. They didn't finish the deposition. And so, and we're complaining about the actions of opposing counsel before the notice of appearance. And I don't know of any rule that says you have privilege to say something to somebody in an email and you can't be shown to the court. That doesn't make any sense. So what you have here is we gave you a Facebook post and we also showed you some emails where before in their appearance.
You're arguing the merits of the motion.
Okay, well, I just wanted to point out that
addressed.
effectively they got a continuance because we didn't get our required discovery.
Well, the record reflects that the respondent got a continuance on November 29.
Absolutely.
That was the first continuance based on misrepresentations to the court, and got the benefit of that, to the significant high potential for detriment to the petitioner. Detriment not only because it's still hanging out there, but at that time it was hanging out there without a temporary injunction in place. And the court precedent and whole specter of weighing continuance with a temporary injunction is wholly different than one when there's not. When we came back, when you were appearing on the respondent's behalf, right at the outset, I said to you, well, now the court has to look at this differently because intervening there was a second, I believe, if not third, but second, I believe, supplemental petition which resulted in a temporary injunction. And despite representations to the contrary, so that Mr. Hales is aware, when the court receives a petition or a supplemental petition as a matter of law, this court must accept what's alleged in the petition as true. Period. End of discussion. The hearings decide if it's true and if it's competent substantial evidence. But the court must accept it as true. So despite allegations that the court is accepting what she says, yeah, as a matter of law, when it's pled in a petition or a supplemental petition, why? Because the court must do so. That's plain and simple. There's no choice in that. When we get to hearing, the court can reject or accept any or all testimony of any witness.
Okay. That's a great point. I want to just touch on that.
Hang on.
Yeah.
That's the second motion to continue that you argued. The respondent's third motion to continue, so that was on 12/1 at 5:56 p.m. The respondent's second motion to continue. Respondent's third motion to continue was 12/5 at 12:53. Respondent's fourth motion to continue was the January 4th proceeding.
Well, that was in conjunction with a motion for discovery violations of not showing up for their depositions.
I hear you. I know why. I've got institutional knowledge of why, but
Every case, every lawyer, I took the case just like Mr. Silverman. We take the case as we see it. And I got short notice, and I said, I'm going to ask. I'm not prepared, and I appreciated Your Honor doing that. But this, I'm just pointing out here that this is a continuance.
What I did as a matter of law was to provide due process to Mr. Hales, your client. I wasn't going to deny him that.
Okay.
And so my question is, why are we suggesting Ms. Preston ought to be denied counsel?
I'm not. I'm saying the opposite. Effectively, they've gotten it already. By her deposition not continuing, the Nettles case, Judge, we have to have discovery, and it didn't finish. Mr.
All right,
Cook's,
let's put it in this context.
Okay.
Everything's about context. Your co-counsel, current co-counsels to this day, Mr. Feather, represented he could complete the case in 15 minutes. In hindsight, in error, this court regretfully allowed the deposition of Ms. Preston to take place in the first place. You're effectively taking a deposition of a litigant who in the middle of her direct testimony is stop, we want to now take her deposition. I regret approving that. It's my understanding from representations of counsel, and we've got a record potentially of what, but it seems to me that that process, which has resulted in, we'll fill in the blank, number of hours of deposition, which you're now saying was unsuccessfully left incomplete, has now, I just heard from Mr. Silverman, also been published to the internet, in addition to your co-counsel, in violation of the Supreme Court Administrative Order, SCAO 11-222, and in violation of AOSC 11-22, and in violation of our Chief Judge's Administrative Order 1.14, version 2. Despite that, he requested and obtained unredacted copies of the 1129 and 12-6 proceedings, and is now answering to contempt charges from the Chief Judge, since it's his administrative order, about what then ends up being disseminated and published on your client's YouTube channel. And so that's another consequence of there being additional time. And now I'm hearing this morning that a deposition has been provided on YouTube. And let me just ask the question, is it a video depo?
Well,
It is a video deposition.
it was improperly noticed as a video depo, does not comply with the rule.
Well, let's follow the rules. That's why I'm asking the question, because there's a rule right on point, 1.310.
There is, and so the notice that was filed on January 15th, I believe it was, in the title, just the title, says notice of taking video deposition by subpoena Ducis Tecum. Putting it in the title does not comply with the rule. You can put things in the title.
I've got the rule right here. Let's go to the family rule. 12.310, subsection B4. Any depo may be recorded by video without leave of court or by stipulation, provided you follow the following rules. A, notice must state in the notice it's to be video with the name and address of the operator. B, the court reporter must be stenographically recorded by a certified court reporter unless otherwise agreed. C, procedure must on camera identify the style, state the date, swear in the witness. D, custody of the tape and copies. The attorney requesting must take custody and be responsible for safeguarding the video.
If I could jump in right there. I did yesterday reach out to Mr. Shockett's office and ask him to provide me with a copy of the videotape, or the video recording. I guess nothing's on tape these days. He directed me to the court reporter indicating that they had custody of that and that I would have to obtain it from them. We had a spirited discussion about the cost of obtaining that. But the notice, although it states notice of video deposition with subpoena Ducis Tecum, I would note there's no subpoena issued to a party, and there hasn't been a subpoena issued to a party in this case, does not contain the information about the videographer. It simply says the deposition will be taken before a court reporter and gives the name of the court reporter and a internet address for the court reporter, and that's it. And regardless of that, if their position is that the deposition wasn't concluded, my understanding is firstly that my client indicated she wanted to read the deposition. She was never provided that opportunity. And just yesterday, Mr. Hales, in one of his many monetized YouTube videos, plastered that video deposition all over YouTube to his 600, 700,000 subscribers, which is highly problematic.
So, Mr. Shockett, while we're talking about your need to redepose an individual who midstream during trial, who your co-counsel only needed 15 minutes to call two witnesses, possibly his own client, argue the case and cross-examine, so that would leave, I'll be generous, leave maybe 10 of those 15 minutes to cross-examine, has now taken several hours of deposition. You have, as his co-counsel. It's not complete. It's now broadcast. Do you agree that it's been broadcast on your client's YouTube channel?
I think I've seen a portion of it, yes.
Okay. Well, let's talk about then whether the deposition in video format was in conformity with 12310B4, and whether in conformity with that rule, you've safeguarded the videotape. And clearly the language of videotape is now whatever format it's otherwise recorded in, inclusive of that.
Well, my client, I gave it to my client, obviously, and, oh, sorry, you turn this on.
Okay, so the rule as I read it, correct me if I'm wrong, the attorney for the party must take custody and must safeguard it. So sharing it with your client, obviously you need to do that to get him prepared to proceed, right. Not a problem there. What did you do to safeguard, to assure that your client, who testified or has made it clear to this court that his I don't know if it's his main source of income, but his source of income is monetizing YouTube videos. That's what's contained in the underlying this entire case, and you hand it to him. And are you on notice that your co-counsel has already, in violation of the Supreme Court order on no prohibition against dissemination, and in violation of our Chief Judge's Eighth Circuit order,
That was the
prohibition against dissemination, despite
video.
attesting to that fact,
I have seen
your
it.
client has now monetized the posting of unredacted court proceedings from 11/29 and 12/6, resulting in a lot of collateral problems directly caused by that. So you know that your client has previously disclosed unredacted videos. You know that your co-counsel is answering to the Chief Judge in contempt proceeding. It would have been concluded yesterday, but your co-counsel was afforded another continuance because he's somewhere and unable to appear in court, and that'll happen next Monday. That's just another side note of accommodation. But that being said, in that context, and in context of this rule of safeguarding the attorney's responsibility, you provide it to your client, and now you know that it's posted on YouTube.
And I'll have a discussion. I will have a discussion. And
What steps have you taken to safeguard and to limit the continued publication of the 11/29 and 12/6 unredacted recordings, audio and video, of this court?
I can't get an attorney-client privilege. but
You don't have to answer that. Did you tell me? Have you done anything?
I have discussions, yes.
Has it
And
been
with-
unsuccessful?
And with Mr. Feather, although he's in the Philippines, I've had discussions about it, and
Will you agree that it's been unsuccessful to date?
I would agree.
Here's the relevance of that question.
I would
The
agree.
relevance is, I have to consider that when you say I want to continue to depose her.
Understood, Judge. If the court so pleases, either way, but I understand your ruling. If you want to overturn the ruling allowing your deposition, if the court so pleases, that's your prerogative. I felt we
Well,
need to
it's
take...
not my prerogative, it's my discretion, because it's granted to the court
Right.
under 1310, which is 12130, subsection 2D. The court, at any time, on motion of party, deponent, or upon showing that the exam is being conducted in bad faith or in such a manner as to unreasonably annoy, embarrass, or oppress the deponent. How about setting a depo that doesn't comport with and comply with 12.310B4, making it a video depo when it's not in compliance with the video depo rule, and then having it published on the internet in a case of cyberstalking that's now gone on since September? How is that not the consequences of now disclosing that video on YouTube, internet, bad faith, or in a manner that might be considered unreasonably annoying or unreasonably embarrassing or oppressing the deponent? So I haven't denied you to take the depo. I'm asking you, why should I allow it to be continued?
Well, that's a different question, because of what happened in the deposition, Judge.
All right, so let's start with, do you agree or disagree that the notice of the deposition that was taken by video as opposed to just audio was proper or improper?
It was technically in compliance. It said video deposition. The court reporter's name was listed on there. I guess hyper-technically, it didn't say videographer instead of court reporter, but it clearly said notice of video deposition. It gave the address. The only thing it didn't say was stenographer or videographer. It just said court reporter.
So the hyper-technical requirements of 12.310, as you put it before, have not been complied with.
That's
So
correct.
the notice was inadequate. The result of that is that you got video footage for your client to publish and to make money on.
I didn't do it for that reason. I did it here to show you exactly. We have it queued up here to show you what
Oh,
happened.
now you want to disseminate it in court? A
wanna
portion
play-
of the video?
I would like to play it for you, yes, Judge.
You all right? Have, just going in my head, about 7 or 8 different objections. to
Well,
that
excuse me,
report.
we also called during the deposition, if you recall, Judge, and there was problems right from the beginning of this deposition. 7 hours, if there were 3 hours of questioning, I'd be amazed.
Okay, so let's say at least 3 hours were fruitful, despite the fact that your co-counsel needed 15 minutes to conclude.
May I address that, Judge? I hear you on that, really do, but after that representation was made, she made another filing on the 4th, which was sufficient to meet her burden under the clear and strong and clear evidence, which you take as truthful, that was the straw that broke the camel's back that issued the temporary injunction.
Well, not really, not really.
No?
And maybe Mr. Hales needs to be aware of this law also. As a matter of law, the court has to take what's pled in this petition or supplemental petition as true. When a petition results in entry of a temporary injunction with a return hearing, that means there's been adequate information contained within that petition to establish the imminent threat. If it's scheduled for hearing without temporary, that means there's a sufficient case to be resolved and adjudicated by the court, but the element of imminent, you can conclude, was not in the petition itself, the initial one in September, was not in the first supplemental petition, and only became adequate, legally adequate, addressing the issue of imminence in what was the second supplemental petition. So the issuance of the temporary injunction was the result of the finding that the allegations in the supplemental petition, when taken as a whole with the previous supplement and the previous petition, established imminent risk. And thus, the court had no choice because I have to accept it as true, and so on. So,
But not subject to cross-examination yet at that point, or not, correct? So it's taken as true without any cross-examination.
right, that's why we're going to have a contested hearing with full due process post a multi-hour deposition that was not in conformity with the rule, that now is on video, broadcast for the entire world to see, that's caused reasonably caused embarrassment, humiliation, potential danger, at least there's allegations of that, and a huge fallout.
Well, but Your Honor, what happened at the deposition is important because she took the fifth on substantive issues.
So when a pro se litigant takes the fifth, you think they really understand? There are lawyers that make objections in this courtroom that are overruled probably 100 times a week. It doesn't mean they're acting in bad faith, but reasonably one could expect they understood. When they say hearsay, they understand the hearsay rule, but a lot of them don't, or the court disagrees with their view of it. Pro se litigant is held to the standard of a reasonably competent attorney, and reasonably competent attorneys make arguments that don't fly in the face of case law or statutory rules and rules of procedure, et cetera. So whether she's using it to say it's irrelevant, or using it to say I'm being annoyed, or using it to truly say it might incriminate me, I don't know the answer to that.
Can I?
What is relevant for today, and I'm hearing you say, is that by virtue of her doing so, you didn't get additional responses that you would otherwise believe you should be entitled to.
Yes, Judge. And also, believe it or not, I actually took the time with her at the deposition to look at the Fifth Amendment, understand, sort of on the same dictionary, if you will. When she says the Fifth Amendment, what does she mean? That's actually part of the transcript.
So you're giving her advice of
No,
counsel?
I said, here's the Fifth Amendment. How do you, when you say...
Oh, so you're expecting a pro se litigant? There are
She got it
lawyers
right,
that
Judge.
come in front of me that don't understand the Fifth Amendment and
But
its
she got it
implications.
right. She got it right. And she also said she had talked to counsel on the record about taking the Fifth. I don't know which counsel that was.
You think you would be entitled to that? To get her, a pro se litigant, in front of you at a depot to disclose what would otherwise be attorney-client privilege?
No, she said it on her own. I talked to an attorney. He said this would take the Fifth, and it's on the record. So she did understand it correctly. It is a problem. She made the statement under oath. She took the Fifth under oath, and there's consequences to that. We don't have to. As far as this, I don't disagree that we need more time to hear our motion today. That's acceptable because again, we have a forced continuance here. Mr. Cook's depot needs to be taken. And
So let me ask you this.
I need maybe an hour more with her.
Your Honor, I have, what was elided from the motion and memorandum they filed is that after I filed my limited notice of appearance, which did include a note not only about the continuance but about potential discovery matters, I did formally I emailed in writing Mr. Shockett, and I did make a motion under 12.310D to suspend both depositions. Again, the deposition of Mr. Cook can be cured if they just figure out how to serve him properly. As to my client, I wasn't even aware at that point that Mr. Hales was going to do what he did yesterday evening and plaster that video all over YouTube. I kind of suspected he might do it. So I wasn't aware that at the time that I made the initial 310D motion. That is an additional ground for my 310D motion. And before a deposition of her resumes at all, if it resumes, I think the court needs to hear that. So that I think is going to have to be left for another day, which is another reason why this case ought to be continued.
Judge, here's the problem. I already said the continuance, it's forced on us. But more important, there was a pending deposition. She agreed on the record, pro se, to continue it tomorrow at 11. We left it around 5:30 or 6. No motion for protective order was filed. Nothing was filed. And this comes from someone who, Judge, as a pro se litigant, who knew to file a motion to reschedule her deposition or to continue it. Nothing was done.
Tell me
You ordered
what
it, Judge.
impact, if any, you believe that subsequent to that. So if you made that argument to me the day after, or the day after that, or the day after that, or let's say any day before your client publishes on the internet for the world to see a video deposition that was not properly in conformity with the rule even noticed to begin with. So do you think that that has some impact on the court's determination of whether this deposition continues?
It has impact.
Okay. And it's detrimental.
It has negative impact.
Okay.
But you have to weigh that, Judge, on,
I'm weighing it.
okay, all right, thank you. And again, as far as the 26th...
Well, let me ask you this too. Why are there excerpts? I look at a filing, again, late last night, which is effectively this morning before this hearing, of, it appears to be excerpts of a deposition because it's like page 5, then it's page 12, then it's page 40, then it's page 60. So it's clearly excerpts. And again, in conformity with the rules, 1310, 12.310, subsection 3, a copy of a deposition may be filed only under certain circumstances in conformity with the rules of general practice and judicial administration 2.425 and in conformity with rule 1.280G, which would require filing with good cause and with minimizing all sensitive information. Was that done?
I believe, yeah, there's just her answers. That's why there was excerpts, Judge.
So, under, hang on a second, let me get, under 1.3103B, if what you're both representing to the court from different perspectives, understood, that the deposition previously taken, or let's call it part of a deposition previously taken, is necessary for this court to review it, then under that subsection, the court can order the complete deposition transcript to be provided to the court. And it would be conditioned upon it being under seal, and it would be conditioned upon it not being broadcast.
You know, there's also the issue that, again, I wasn't at the deposition, but my client tells me, I asked her about reading or waiving, and she indicates to me that she informed Mr. Shockett that she wished to read through the deposition and have the opportunity to complete an errata sheet. That was not done. I don't know why a deposition or parts thereof are being selectively put into the court record for this court and for the public to read when, one, they're claiming the deposition has not concluded yet, and two, she has not been given an opportunity to read it and sign off on it or complete an errata sheet, at least as to the initial portion.
Mr. Zimmerman wasn't here. We addressed that with Your Honor. She had until, I think, today to do an errata sheet.
She wasn't even asked. The court
Yes,
reporter
she
never
was.
contacted her.
It's on the court reporter. She gave an email address on the record, and I can find out if the court reporter gave it to her. But that was on the record.
If she had until today, why was the video plastered on the internet last night?
Right, and posted.
Why was it put in this
we don't
pleading
know.
last night?
We don't know what happened with the errata sheet. I can find out. I'm sure it was sent to her.
No, but we do know that what you just said is that she still has time to do the errata sheet, and instead, a not properly noticed video deposition has now been posted, and excerpts of the transcript have been placed in the court file.
Understood, Judge. And I understand what you're saying about a negative inference as to whether the debit goes forward.
What's your sense, Mr. Shockett, as to the request, in effect, that if it can be continued from January 6th, that
26th?
2 weeks or so, excuse me, January 26th, yeah, that if it's to be continued from that date, the court would be proposing February 9 as the day. So that's basically a 2-week continuance.
I think the fact that Mr. Schulman's here, the deposition will conclude very easily of Ms. Preston. I think that Mr. Cook's deposition can be taken in a half a day. And if he wants to take my clients, I think he can, I don't know how much time he wants for that, but I don't see it as insurmountable, except for this issue with the rata sheets. Again, we should address it the same way we did with Ms. Preston and Mr. Cook. Give a short window.
Let me ask Mr. Silverman, do you have a sense of how much time you think you would need on the deposition of the respondent?
I would think I would need 2 to 3 hours, probably not even quite that much, Your Honor. We're talking about a hearing that's only supposed to last another 2 or 3 hours. And so, first of all, let me say to the court, I'm available all day on Friday, February 9th. Let me just triple check that. I'm available all day that day. The boss tells me I'm available all that day. The second thing I'll say is that at this point, unless the court specifically orders otherwise, I do not intend to have my client sit for any further deposition. As to Mr. Cook, if they can figure out how to serve him properly, more power to him, and I'll certainly accommodate that. I will also tell the court and Mr. Shockett that I will do evenings, I will do weekends, if we can find a court reporter who will do that, to accommodate getting these depositions done before February 9th, and hopefully getting them done a reasonable period before February 9th so both parties don't have to come out of pocket an outrageous sum of money for expedited transcripts. But again, I'm not conceding that my client is going to sit for any further deposition for a variety of reasons, many of which we've touched on this morning, Your Honor.
Your Honor, if I could, on the calendar thing, I have a case in Dade County, and it's a 2017 insurance case, 2018 case, and the court's indicated that I have a deposition of my expert, and that court indicated that it's going to go to trial in March when this expert deposition finally is taken. It's on the 9th that day. I'll leave it to you. If you want to give me something that says to this judge, I can,
Your
change
Honor,
that depo.
my client and I are willing to accommodate Mr. Shockett because he has another obligation on that Friday. I can tell the court that I can make the following Friday, the 16th of February, work. Correct? My child has a doctor's appointment that day. I will have it rescheduled.
The court,
Is Friday the day we do it? Is that?
I'm sorry?
It's just Fridays? Is that how it is?
No, it's just what the court can accommodate.
Right.
The next day I was going to suggest is February 5. So that's civil trial. That's a full civil trial week. The reason why the court has those 2 days available is because the civil cases scheduled for the month of February have settled. As a result, this court now has a full-day trial on the 6th, a full-day trial on the 8th, a half-day obligation for the domestic violence docket, a court-issue meeting, summary judgment motions, and a bunch of other things. And it opened a week or 2 ago. It's 3 days of now full. The 9th is available and the 5th is available.
I can do the 5th. I have a deposition that's a regular one. I can reschedule that.
Your Honor, I can do the morning of the 5th. The afternoon of the 5th, I'm in a multi-hour hearing with Judge Fiegel in Dixie County on a child abuse case that has been specially set, so I can't move that, but I am available in the morning.
Let's go back to talking about the 9th regarding, because here's the other thing is I want to provide a little more time rather than less time, which is why I suggested the 9th first. Mr. Shockett, what's the deposition you have to take on that day for the expected trial?
Yeah, it's an expert deposition. He's a University of Florida engineer.
Are you doing that by Zoom, or
It is by Zoom.
so you're going to remain somewhere here, not
Yeah,
having
in
to
the
go to
Trenton. Yeah. It's set for 10 a.m.
I can, on the 12th, will Struping continue the trial? Remove that trial?
I can tell you this, that the next full day, despite the fact that, again, back on November 29, the court had previously scheduled matters for the 30th, but felt it important enough to both litigants to offer that day, and the record would reflect, I said I would cancel what I already had, and I would accommodate these litigants, and that was denied. And literally, there's not another day, and I'm just in abundance of caution needing a full day for this. till March 1, and that's just too far out. So
I can make March 1 work, Your Honor.
Well, probably we all could, but the consequences of time that are reasonably expected based on the negative consequences to the fair administration of justice, the orderly administration of justice, the compliance with rules promulgated by the Florida Supreme Court and the Chief Judge of the Eighth Circuit being violated, the court has concerns about the length of time and what might happen between now and then.
It would be, and I certainly understand the court's concerns, as I indicated in an email to Ms. Cummings, Chief Judge Mosley's JA, on which Mr. Shockett was copied. I can't be here next Monday for that hearing. Chief Judge Mosley indicated that neither my client nor I need to be here, and quite frankly, we don't have a dog in that fight. That's between the courts and Mr. Feather. I will hopefully think those order to show cause proceedings have impressed upon counsel the need to protect and comply with the videos in accordance with the administrative order. Certainly, if depositions go forward in this case, regardless of who the depositions are of, I will be asking the court to impose a protective order barring any publication, period, except in accordance with the rules of procedure. So I think we could address it there. As I indicated, I can make the morning of the 5th work. I do think that's likely too soon to get everything accomplished. That basically gives us a week to get the depositions done, and I will certainly endeavor to do that, though it does look like it'll have to be in the evenings or on the weekend to get those depositions done. Alternatively, if they're okay with the 1st, I can make that work as well, and that will give both sides plenty of opportunity to conduct the discovery. Hopefully, Mr. Hale's side of the aisle has gotten the message regarding the need to safeguard witness testimony, information, and videos.
I can make the 1st work by moving things around. It's really weird. If someone doesn't go to the doctor very much, I actually have an appointment, which it's not life-threatening. I'll just change it.
I'm more inclined to do the February 9 if you could otherwise accommodate that date.
Okay, I can just ask this other judge, Cheeseman is her name,
Okay, and they could reach out to this court.
if we can reschedule it.
So
But if absent that judge, I just know this is a 17 case, I don't think she's gonna,
here's the other issue that your client needs to be aware of from the court's perspective and consistent with the statutory provisions that mandate upon continuance for good cause, the terms of the temporary injunction will remain in effect.
can I be heard on that, Judge?
Sure?
So, you mentioned about the totality of the circumstances, each pleading, each petition has its say, 50 pages the first time in September, 334 pages in October. Each time it's weighing. The December 4th one, as you said, the cumulative effect was the barrier, her burden of proof was reached in order to effect, which I think it's strong and clear evidence. I think that's the language for ex parte.
On the issue of imminent,
Imminent,
which
okay.
was
But
not
what's
sufficient.
happened, but that was still subject to cross-examination. She's been asked questions under oath, and she's taken the 5th. And I think at that point, there's a negative inference to make. And please, Judge, this is important because now I think that at least that, plus the fact that a continuance was effectively done by not allowing the depositions that you ordered, not just her, Mr. Cook on the 17th, no show. I think now you have to at least take the fact that she took the 5th, the substantive question, and say maybe that lowers it so that we don't reach the burden of imminent and the evidence, her burden has not been met.
Yeah, but since that time, so then part of the nature of the initial complaint to be adjudicated by the court is the dissemination publicly of broadcast images and documentation, videography, whatever it is, about her that she's claiming is causing her substantial emotional distress. That's to be decided by the court at some point when I get all the evidence.
Right, but Budlove says that you can still use their name. You can do that as long as you don't have unprotected speech that's, insightful, fighting words.
And I'm the one that not only narrowly tailored it before the Budlove decision, the court then, in conformity with that decision, modified it again for your client's benefit in conformity with the law. But it's another one of these balancing things, which is 2 more weeks of your client having the temporary injunction. But what I'm saying is, what's happened since entry of this injunction, here's the totality of the circumstances.
Okay.
On November 29, his attorney, your co-counsel, when the court said, I will accommodate the litigants, I will cancel what I have, we can come back at 9 in the morning. That was 5 p.m. the day before. Your co-counsel said the following, quote, this was on 11/29 at 4:53 and 15 seconds to 4:53 and 47 seconds. No, Your Honor, Mr. Hales is having to address matters in Ohio court related to this situation. He has to be there tomorrow morning. That's what was represented. That's what gained your client a continuance. That was a misrepresentation because on 12/6 at 1:33 and 49 seconds through 1:43 and 45 seconds, current counsel, Mr. Shockett, yourself, and questioning of Mr. Hales on a compliance issue, established that he did not have a court appearance the following morning. That in fact he went to Ohio to sign documents 2 days later in his lawyer's office. That's the first continuance gained on misrepresentations to this court and less than candid representation. Then, 12/1/556, respondent's second motion to continue by Mr. Feather, which was inadequately pled, was filed at the last minute, did nothing to establish that it was something that arose between him agreeing to the date of 12/6 and the date that he filed this second motion to continue on 12/1. It did nothing to say that something arose unexpectedly that caused him not to be available, and it resulted in then you filing a notice of appearance and saying 24 hours and 20 minutes earlier, I need a continuance because I can't possibly be prepared, which the court again accommodated for Mr. Hales. And Mr. Hales, as I mentioned earlier, hired an attorney he knew could not be prepared. He knew he had a calendar conflict or at least time conflict to be prepared adequately, and he was accommodated. I've got no regrets about that decision. It's in conformity with the law and the circumstances. But the circumstances then included, on 12/5, third motion to continue of the respondent.
I think that's mine, Judge.
That was yours? Yeah. Okay, that was, right. So they were like 3 days apart. We heard it on the same day. One I resolved outside the presence of a hearing, which was Feather's motion. Yours we did at subsequent hearing. The fourth motion to continue was the January 4. As I said before, in hindsight, the court felt it was error to allow that, as effectively we were midway through trial. Addition to that, and you guys are very well aware, and these matters are currently under investigation by the state attorney and or the Levy County Sheriff's Office under their obligation under Florida Statute 784.0487. 12/6, there's an allegation for violation of the injunction which implicates you, Mr. Shockett. 12/27, another motion for contempt. 12/29, additional motion for contempt. 2 of them on January 2nd. There's now contempt proceedings ordered to show cause on Attorney Feather with the Chief Judge of this 8th Circuit. There's, in addition to all of those moving parts and developments, this court, again to accommodate the respondent, and again in conformity with the law, this court had previously narrowly tailored the language because there was not any, and I pointed this out in December, I pointed this out I believe in November, there were no DCA opinions subsequent to the October of 2021 statutory change which added 6 words, and as I pointed out in the footnote in the case of Strober versus Harris, 2nd District Court of Appeals, when they remanded it back, they said, oh, by the way, the statute changed, implying that you need to maybe reevaluate this as the trial court in light of that statutory change. Nonetheless, the court narrowly tailored it, again, in conformity with Budlove, decided by the 2nd DCA on December 29. I modified the language again to accommodate him and to not restrict in the balance of things his First Amendment rights. Since then, we now have the posting of unredacted court proceedings from November 29 and 12/6 in violation of Supreme Court orders and this Chief Judge's order. We now learn today, this court now learns today, that there's also been publication and broadcast of a video deposition that was not taken in conformity with 12.310B4, and which has now been disseminated to the public. The consequences to the court include fallout of hate mail, hate telephone communication. It disrupts the orderly administration of justice. It increases potential harm to the litigant who's brought this action. It includes potential violations of oaths of attorneys or attorney, one who's answering to the chief judge. The court perceives those totality of circumstances as increasing the potential for additional potential harassment and or violations of rules of the court. It also increases the possibility of violations of the terms of the injunction. It increases the possibility, because the evidence would show that disclosure of what would otherwise be protected information that should have gone through a redaction process, and in the case of the video depo, should have been in conformity with the rules on posting or filing with the court and noticing it in the first place. And what appears to be a continuation of the behavior and arguably enhancement, increased behavior that is troubling to this court. This matter needs to proceed to be resolved on February 9 with the temporary terms of the injunction as previously modified. Needs to remain in effect. It's the only way to assure, and again, I'm not insensitive to the fact that it's 2 more weeks, Mr. Hales, but in conformity with this court's obligation under the law and based on the totality of those circumstances, and there are more, there were 3 full hearings, if not 4 or 5 different court proceedings where all of it is outlined, as well as what's filed within the court record. The temporary terms of the injunction will remain in effect, as I said, as modified and issued on January 4, 2024. So I'm going to direct the clerk to prepare an amended, not amended, a third extended temporary injunction for protection against stalking with the addendum previously made part of that order, which was page 5 of the 7 pages issued on January 4. Mr. Hales, you're directed to comply with the terms of that injunction through February 9. On February 9, we'll adjudicate the merits of the case. With respect to the request for additional depositions, based on the totality of the circumstances, the request to depose or further depose the petitioner is denied. With respect to the deposition of Mr. Cook, who is not under the control, at least there's no evidence is under the control of Ms. Preston, is just a witness, certainly available to both parties upon proper subpoena and process to serve him with subpoena for deposition.
I think you mean Mr. Cook.
Mr. Cook?
Yeah.
Did I say Cook?
You said Preston.
I'm sorry.
You mean John?
Mr. Cook.
John Cook.
Okay.
That deposition, again, if it's taken in conformity with the rules of scheduling a deposition, setting a deposition, noticing a deposition, subpoena for deposition, if it's in conformity with the rules, may take place and needs to be concluded by February 2. Likewise, and I'll build an exception for that. I'm going to leave it to counsel. But by February 2, likewise, the deposition requested by petitioner's counsel of the respondent needs to be concluded by February 2. As to the Cook deposition, in part, given what has already been represented as maybe a 3-hour productive deposition of the petitioner, based in part on the request of counsel for the petitioner seeking about 3 hours of the respondent, based in large part on this court's knowledge of the issues to be litigated and adjudicated. The court will allow the deposition of Mr. Cook to take place up to 3 hours, but not beyond. the deposition of Mr. Hales by the petitioner's counsel up to 3 hours, but not beyond, that they be completed by February 2nd unless both counsel agree in writing to another date. So I'm giving you guys that opportunity so you don't have to come back to court to change it. If you both are agreeing, you don't need a stipulated order changing this order. So I'm giving you to February 2nd. That should give you another week to get the transcripts if needed. I would suggest you try to, when we adjourn for the day, start working towards agreeing on what that date and what those times would be. And if, like, your calendars, for instance, work and it can happen February 3, you don't have to come back to the court, but you guys have to agree in writing to any change in date. And again, all those depots need to be in conformity with the rules regarding setting depositions and taking depositions.
I need to be heard on something, Judge. I have an expert witness that's going to testify in this case. It's a forensic expert. And I just texted her. Her name is Diane Peterson. And I just texted her. She's not available. Her granddaughter's giving birth. The due date is the 10th. I just had an exchange with her. I don't want this continued, but I think she's a material, important witness.
Where is she going to be physically on
Tennessee.
the night?
She's in whatever that mountain area is in Tennessee, whatever that city is, north of Atlanta, where the mountains are. I want to say Chattanooga, but maybe not. But anyway, she's from Tennessee. She's supposed to fly into Gainesville and appear, but
Why can't she appear by video conference?
if there's no objection.
Well, so this is the first time I've heard the name. We just Googled her. Apparently she's some kind of handwriting expert. I normally never object to anybody appearing by Zoom unless it's a party or an expert, and particularly if she's going to be referring to documents, showing documents to the court, comparing documents. I absolutely have an objection to her appearing by Zoom. So, and again, this is the first time I've heard the name. I can't imagine how a handwriting expert would have any relevance to these proceedings. There may be Dahlberg objections, things of that nature. There may be voir dire that needs to be conducted. Our position is she needs to be here in Levy County.
I agree. So, Counsel, what you're telling me, Mr. Shockey, you're saying that she represents that she expects to have to be in Tennessee on the 10th.
As of a minute ago. I need it later in the month. That's one day before the due date.
So,
And the dots are going right now, so she's saying some additional stuff.
I know, but, and I know you're representing what she's representing to you, but
Would you like to call? We can call her.
If you want to take a brief break to talk to her, because here's the issue. She gets here, I mean, we can't make decisions based on the prospect that the 10th may be,
Of a baby.
for lack of a better term, the biological time clock, coming to fruition and her need to be there. I don't want to deny her that opportunity by any means, but I guess it's a scientific hypothesis. I don't know what she knows about the 10th and calling it a due date, but nonetheless, it's otherwise impacting our ability to proceed. And I do agree to some extent that kind of a witness is best handled by both counsel in person.
Your Honor, if they intend to call this witness, I am going to, and I'm not arguing with the court, but in light of this new information, I am going to renew my request that the court consider placing this on March 1st. I would also ask, I would want to depose an expert witness, obviously. We don't have time for requests to produce and things of that nature, so I'd be asking the court, moving Lord Tennis this morning, to require that any written work product that they intend to rely upon be turned over to my office no more than 48 hours before, or no less than 48 hours before any deposition in the case. Obviously, we'd have to get with Mr. Shockett's office to schedule that and take into consideration the expert's calendar as well. But again, if I keep coming back to, and I wasn't here for this, but the court's mentioned it several times, the whole 15 minutes to present their case. I don't know how you include an expert in that. But with that said, if they are announcing their intent to call an expert witness, there's no pretrial order in this case, there's no witness disclosure. I do intend to depose her, and I do wish to have her information beforehand.
She's available March 1st.
He showed me a text which just confirmed that. However, just so we're clear, if the court does continue to March 1st, our request to keep the temporary in effect will remain the same. I understand that the additional length of time may factor into the court's analysis, but I wanted to be clear on the record that my client would be asking that the temporary remain in effect. And I think for all the reasons the court has recited, which I think essentially comes down to unclean hands on the part of Mr. Hales and counsel, not counsel, Mr. Hales, as to how they've handled this process. I think that extension of the temporary is appropriate, whether it's February 9th or March 1st.
So, Mr. Shockett, you need a chance or a moment to discuss with Mr. Hales that if what you're asking for, in effect, is a continuance to March 1, given the expected unavailability of what you feel to be an essential witness for his case, the court would consider doing so, but it would be subject to the third extended temporary injunction containing language similar to the second one, and instead of through February 9, it would be through March 1.
I have no problem with the temporary injunction with 500 feet. I never go back there anyway. I'm fine with
What about March 1st?
It's fine. I just need to drive on the road so I don't die. The whole road was blocked off.
Your Honor, okay, yes, we don't object to the March 1st. But again, I know we've revisited this. Mr. Hales is obeying by the injunction to the T, including this issue about the public road. And he's said again, there was an accident last week on that road. It's a busy highway. He just wants to be able to drive on the road to get into his property, making it within 100 feet when it's their residence instead of 500.
That request, based on matters previously argued before the court on 2 occasions, is denied.
Your Honor, I would ask the
Of
court,
course it pleases.
in light of the new date being March 1st, I would ask the court to permit both sides some additional time on the discovery. Instead of next Friday the 2nd, I'd ask the court to allow us until Friday the 16th, which would be 2 weeks before the hearing date, to complete the depositions.
That's fine, Judge.
Okay, without opposition, all other matters, as I said, instead of the 2/2 cutoff date, it'd be February 16.
Would the court entertain my or tennis motion to direct Mr. Hales through counsel to provide to me and my office all written materials or other work product that this expert has relied upon or would rely upon at the hearing no less than 48 hours prior to her deposition, whenever we are able to schedule that?
If she's got a written report, yeah, I haven't seen it yet, but sure.
Well,
We're not going to ambush anybody. Sure, if we get a report, we'll provide it.
Not just a written report, but any materials that she relied upon
I'll get you that.
informing any opinion that she intends to testify or may testify to in this case.
Absolutely.
Okay, without opposition, the court would direct that 48 hours prior to the deposition of the person proffered as a potential expert witness, all materials relied upon to formulate her opinion and/or any reports generated from those materials will be provided to counsel for the petitioner at least 48 hours prior to the deposition. With regards to the scheduling of her deposition, as well as any and all other discovery, I want to put a cutoff date. We're now at February 16 for the Cook and Hales deposition.
And we could do her deposition by Zoom, I presume. Is that right, Mr.
Where is she located?
Tennessee, somewhere.
So I know you said she's going to be in Tennessee for the birth of the child or grandchild, but does she live in Tennessee?
She lives in Tennessee.
Well, yes, given the rules of procedure and the controlling law, I would have to consent to a Zoom depot there. Not for the hearing, but for the depot.
Right.
I would be inclined to provide you all opportunity to do so by February 21, which is middle of the following week after the other depots need to be completed. Is there consensus on that?
That's perfectly acceptable on our side, Your Honor.
Yeah.
Sorry, go ahead.
So what was the date? We had 2/9?
2/16.
No, the one that we couldn't make it was the 9th?
The February 9th date is now going to be changed
Right.
to March 1. Madam Clerk, the extended injunction will go through March
Okay,
1.
so her conflict was the 9th, so yeah, that should be.
9 a.m., correct?
The baby's going to be that weekend.
Your Honor, I do not intend to notice Mr. Hales' deposition as a video deposition. The rule certainly permits Mr. Hales to, with the appropriate filing, make his deposition a video deposition. I would move or tennis this morning that the court direct to both parties, really, we can make it reciprocal, but really direct them, that if any deposition is video recorded, whether properly or improperly, well, it shouldn't be done improperly, but if any deposition is video recorded, that it absolutely not be disseminated in any way, shape, or form until we come back on March 1st, and this court is able to rule on that.
Yes.
That includes going on YouTube. That includes any transcript being posted on YouTube?
Yes, absolutely.
Without opposition, the court would also direct that neither party, if any depots are taken in conformity with the videotaping of deposition rule, that neither party disseminate or publish in any form whatsoever those depositions until we reconvene and readdress that issue.
And
Through March 1 at 9 a.m., which the temporary is going to remain in effect.
one final point, if I could, Judge. I know you're not allowing further deposition to occur, and if that's, the court so pleases, that's fine. But we should still be allowed to use it. Is that correct, what we have so far, the transcript in court to impeach and look for whether?
If it otherwise meets the criteria for, prior inconsistent statement or whatever,
Okay,
yeah, and subject to whatever evidentiary objections. I'm not denying anyone the opportunity to present it. I'm not denying anyone the opportunity to make appropriate evidentiary objections at the time.
thank you, Judge.
I know that the terms of the temporary injunction will be contained in the document the clerk is preparing. In an abundance of caution, would the court permit me at the conclusion of this hearing simply to remain, and I'd like to draft immediately a proposed order for Mr. Shockett's review and the court's review on the discovery procedures we've just outlined so that everybody's obligations are clear on the record.
I have time.
Well,
Sure.
so let me ask you how you're going to type it up and forward it to me, and we could.
We'll stay right here or go in the conference room, whatever the bailiff pleases, and send it to Mr. Shockett as soon as I'm done. It should take me about 20 minutes. I'm not saying the court has to sign it immediately. I just want to get it
Consensus
on
on
paper.
the language.
Yeah, well, it's fresh in my mind.
Well, you can email, right?
Right, I can email it to Mr. Shockett.
I might have to go back to the office.
But I want to know if the court will sign an order, an agreed upon order that has all those procedures in it.
I'm here. I'll execute that without delay.
And then lastly, Your Honor, I know there has been a lot of discussion on both sides about violations or potential violations of this injunction and an Ohio injunction. I believe there's been allegations of things that have occurred at the courthouse. I am requesting, Mr. Bailiff, that either you or one of your colleagues walk my client out to her vehicle and watch her leave the parking lot. I don't want there to be any discussion about potential contact between these parties, and I don't want to walk her out myself because I don't want to make myself a witness in my own case.
Can we accommodate that? Okay. We'll accommodate that.
Give me just a second.
Just so the record's clear, because the extended injunction, which contains the addendum that was previously added to it as page 5 of 7, signed January 4, 2024, the same language applies in conformity with the Bud Love decision. Just so that you know, I've written in here so that this record reflects that the above conditions will remain through March 1, 2024, dated this 23rd day of January 2024, signed by the
That's fine.
court.
And what time, 9 o'clock?
9 o'clock.
Okay.
And I know I said last thing, but never trust a lawyer when he says that. This is a relatively unusual procedural posture in that this hearing has already begun, the evidentiary portion of this. I am now on the record moving to invoke the rule of sequestration as to any and all witnesses that may potentially testify in this case. I certainly have no problem with Mr. Hales or my clients speak to their lawyers about it, or if the lawyers speak to other witnesses about it, but I believe it's completely inappropriate given that the evidentiary portion of this proceeding has already begun for there to be conversations about the substance of what has occurred in court and what other witnesses testified to. So I would move to invoke the rule of sequestration.
Mr. Shockett, you wish to be heard? I mean, it's a...
No,
it's-
I agree. That's been a problem in this case that I've seen before.
All right,
So for example, his wife, I believe it's his wife,
It's not as well.
or well, his significant other, they're on YouTube chatting for hours about what has occurred in court, what witnesses have testified to, what happened at depositions. That is not kosher, respectfully, while the evidentiary portion of this case is pending and the rule has been invoked.
So, for the record, if you could just state the name of the individual that you're talking about, Mr. Shockett.
Well, we saw two witnesses here on their side. We saw Russ, what's his last name?
Sus.
Su-
Russ, the sus.
Russell,
Senior.
the former mayor of Otter Creek was here, was a witness. He was here, so that was one. I think there was another witness she had.
It would apply equally.
It would apply equally. I
Applies
agree.
equally.
Absolutely.
Right.
And then
So I just want the
Martha-
record to reflect so that the parties know. It's a little bit unusual because the court would have invoked it at the outset. Mr. Silverman was not present at that time. It was not raised by Mr. Feather or Ms. Preston acting on her own behalf. So the court would invoke the rule of sequestration of witnesses, which would include that the witnesses remain outside the courtroom during the presence of, the presentation of the evidence, that the witnesses, while outside the presence of the other witnesses, not discuss amongst themselves their testimony or expected testimony, or if they're called before the other witnesses, what they did testify to or what they were questioned about, that any violation of the rule brought to the court's attention will result in an inquiry and potential exclusion of their testimony. And so, Mr. Shockett, what you mentioned just a moment ago as to maybe the mayor or former mayor, I may have been mistaken. I thought Mr. Feather represented him as a potential witness he was going to call.
That was the current mayor.
Okay.
And then there was the
So-
the current mayor and former mayor.
Here's the dicey part, because normally I would have identified those witnesses if I had them step forward. So the current mayor of the town
Current mayor.
council of Otter Creek, the
Was-
former mayor,
That was on our potentially may show up, we'll invoke the rule.
okay?
On her side was a former mayor and an unidentified person.
Okay,
that were wit-
so, Mr. Silverman, you're charged with discussing with your client any potential witnesses that she not discuss with them the testimony or expected testimony. Mr. Hales, likewise the same, any witnesses that you intend to call. When each witness is going to be called, when we reconvene on March 1, we'll have brief inquiry before they're called. The court will inquire, have you discussed this matter with any of the other named witnesses in this case? If so, to what extent and when? And the court at that time will consider potential sanctions for exclusion of them as witnesses. So we're effectively, midway in a trial, and we're going to reconvene on March 1, which is another, in the balance of all things considered, concern of the court by going that far out.
One last housekeeping thing, Judge. The Supreme Court issued, there's a new rule, 1.041, which is not effective until April 1st. So we still have family law 12.040E on limited appearances. Now that we have this, I've asked Mr. Silverman to make a full appearance rather than that limited appearance. The rule also required 12.04E that every filing, every pleading with the court in his signature line say he has a limited appearance for these purposes. It wasn't followed. That's okay. But I don't think we need a limited appearance at this point.
Mr. Silverman, you intend to do so now that you're past the January 26th calendar conflict?
Well, yes, I do. We will file a plenary notice of appearance today, and I would note that the motion to continue, which is the only pleading I filed in this case, does note directly below my signature block, counsel on a limited basis for the petitioner. So I'm not quite sure what Mr. Shoppett's referring to, but I did not comply with the rules, but I most certainly did. I would also note that my motion to continue was signed by my client as required by the relevant rule of judicial administration, whereas some other ones I've seen in this case have not been. But I'm not so much concerned with where we've been. I'm more concerned with where we're going, and hopefully Mr. Shockett and I can work cooperatively to try to resolve as many issues in this case as we can and litigate only those issues which need to be litigated.
At the risk of going down a path that may be unnecessary, the record needs to be clear. I've got the notice of limited appearance filed January 17, 2024 at 8:38:04 a.m. It's a notice of limited appearance. It clearly states in the body of it, it's for the limited purpose of preparing, filing, and litigating the motion to continue. That's what happened today. And in the signature block, it's signed by Attorney Joshua Silverman, and under all of the identifying information, contact information, e-service info, It states limited counsel for the petitioner.
I didn't mean that. We meant the other filings. It says, the rule says that's currently in effect. Any pleading or other document filed shall state in bold type on the signature page of that pleading, attorney for petitioner for the limited purpose of blank. And then whatever that notice said, repeated.
Okay, well, it's going to be remedied by a
It's gonna be
notice
remedied.
of appearance.
That's all. I just wanted to get
The
it.
court will acknowledge, and we'll proceed. Just give us a minute here. We're good with that? Okay. We'll serve Mr. Hales with a copy of the extension of the injunction through March 1.
Sure.
There's 2 copies, one for him.
Ms. Preston, I ask you to sign, please. You okay?
Right here.
Yes, ma'am. Would you prefer that I go to the conference room to finish this writing, or do it here? Go on with that. Brent, get that scanned, please.
All right, anything further to come before the court on behalf of the petitioner?
No, sir.
On behalf of the respondent?
No, Your Honor.
Thank you. We'll stand adjourned.